Welcome to Latte with a Lawyer, a podcast dedicated to bringing you the stories of some of America's most successful lawyers, figuring out what makes them tick, how they creatively solve problems, and how others, aspiring to be them, can follow in their footsteps. Here's your host, Jacob Wells.
All right, welcome to Latte with the Lawyer. I'm your host, Jacob Wells, and today I'm really excited because we have a great episode for you. We're going to be talking with Rebecca Horton about how she started out in the government side of law and then transitioned to work for Polsinelli, where she works with intellectual property and technology litigation. So here's our guest, Rebecca Horton. Welcome to the show.
Thanks, Jacob. I'm excited. I mean, it's always an easier topic to talk about, your own career journey to the, where I am at this point. So I'm happy to share that, and maybe it'll be some interesting tidbits for people to hear about.
Great. Well, thanks again for spending some of your time with us today. I have to ask you before we get into the episode, since our show is called Latte with the Lawyer, what is your morning drink of choice? What gets you ready for your busy day ahead?
That's a good question. I mean, anything of the caffeine variety. I have come to realize that espresso is probably the quickest thing to do the job, and so probably an Americano is going to be the direction I go. And then, but I would be misleading if I said it's just one Americano to start the morning. It's usually one or two, and then maybe an afternoon one as well.
No. I hear you. I had an Americano phase for a bit, and I feel like it's hard to stay with just one drink. You got to switch it up a bit. So definitely hear that. So let's take it all the way back to when you worked in the government side of things, and I know you did some trials back then. So what was that like, and how did you get interested in law in the first place?
Sure. I mean, that part goes way back to a point that I probably can't even pinpoint. At a really young age, I must have seen a TV show or something, but I just kind of decided that I was going to be a trial lawyer. And I didn't really know what that meant because no one in my family was a trial lawyer. I didn't really have any sort of examples. I probably was in elementary school at the time, but I just made that decision that was what I was going to do. And then from there on out, I think it was just a self-fulfilling prophecy. I mean, my family then, in your standard sort of debates or arguments that you have with your parents, I tried to correct them or kind of persuade them to let me do whatever I wanted to do. And they would tell me to stop lawyering them. Not that I knew what that meant. But then, so that kind of propagated it. And then from there on out, I mean, I did opportunities in high school. There were a few opportunities to do moot court or mock trial. And so I did those. I did a week-long program at UCLA that they had for high school students. And so I had these varying sort of opportunities that reinforced my desire to be a trial lawyer, and the fact that I liked the art of debate, and I liked the competition part of it too. Having played sports my entire life, it had a lot of aspects that I really enjoyed. And then, as I learned more about the opportunities in being a lawyer, because there's just so many ways in which you can practice law or get a law degree and not practice law, but you can kind of use that to segue elsewhere. And I just realized that it touched so many different types of industries that even if, I were to change my mind down the road, or I wouldn't necessarily want to be, a trial lawyer per se, but I might want to take that and segue that into another industry, there's ways to do that. So I liked that versatility. I think a big part too is I graduated college in the recession. And so all of a sudden, you're graduating school, you're not making much money, you're kind of looking for your first job. And I saw just how uncertain sometimes the economy can be. And so can you figure out a job, a career that there will always be an opportunity to be able to, provide for yourself and to support yourself. And so, graduating in that time, I think had a very real impact on being very meticulous about any decisions I made, and to ensure that I could always be able to support myself in whatever route I took in pursuing law.
Absolutely. I think that's a really interesting origin story. And there's something specific that you said about playing sports all your life that I actually want to hone in on a little bit more, because I heard recently, I think it was Brian Panish who played college football, and he talks about how, being coached at a young age and being very competitive, like, helped him become the successful lawyer that he is. So I was just curious, thinking back about when you played sports, is there anything, that you feel similarly, or how it helped you become a successful lawyer?
Sure. I mean, I think every aspect of playing sports translates to professional and personal life. But, I think the learning how to work within a team dynamic and learning about the working hard for the benefit of a team, and learning how to navigate, the desire to be the best you can be, but that's not necessarily adverse to your teammates being the best that they can be. I think just within the dynamic of women and working with a group of women, on the teams I was on, they were all women. And so working together with other women and just kind of working to support each other and having that camaraderie, and it's just so invaluable, I think. I think the discipline that comes with sports, especially playing it up through whatever level, but for me, playing it up through college and Division I was huge, because it really just forced you to prioritize at a younger age. At 18, you're expected to perform at a certain level academically, but also in turn expected to perform a certain level athletically, and the demands on your time. You just don't have as much available time, and you have to be able to perform in both those areas. So you're very just aware of becoming more efficient as to maximize production. And just the fact that you make that decision to dedicate your time and effort to something and then following that through. And then I think one additional aspect of it that I think taught me a lot was when you fail, which you often do in sports, right? You don't make that winning shot. You don't, your pass, goes out of bounds, and then all of a sudden it's a turnover and then they win the game. You have these moments that really require you to learn how to process emotions in this heated setting and turn them into something productive. And for me, kind of the ultimate aspect of that was actually my senior season. I blew out my knee halfway through my senior season. So I went these 3.5 years working so hard, making all these sacrifices and, being part of this team. And then I just was out. There was no chance of, rehabbing before the end of the season. And I was a captain of my team that time. And all of a sudden I could no longer lead on the field. And so I had to really learn how to adjust. I mean, it was just so depressing, but at the same point too, my team still had a half a season left, and you wanted to ensure that morale stayed high, and they adjusted accordingly, and then to maximize the remaining of the season. And so I actually was like, well, if I can't lead on the field, what else can I do? So I convinced my coaches to make me an assistant coach, which I don't know if that really changed much of, I was probably outspoken regardless of whether or not I had that title, but I think it allowed me to kind of adjust into that role, and my teammates were able to adjust with me in that role to kind of become more of a coach than a leader on the field and in the middle of the field. And just the whole process of that, just utter devastating injury, and having to kind of turn that around to make it as best as possible. I think that comes up a lot in your professional and your personal life, and I learned a lot from experiences like that.
Yeah, I think it's really interesting how many parallels are in the teammate aspect. Wasn't one I had thought about, but as you were talking, I was thinking that it's kind of like similar when you go into the courtroom. It's similar to being on the field, on the court. Like, it's game time. You have to get into the zone. It's very performative in that respect. So I wonder, was there a certain case that you worked on that really stuck out as being, like really exciting, something that you were really excited to be a part of?
Well, it just even the part that you're just talking about kind of like the pump up that you usually do for games, like, all our team would listen to music. I had my own like play mix. I don't even know if that's the term used anymore.
Yeah.
I had like the songs I listened to that I got super, pumped up for games. I actually found myself actually using that too, going into court.
Oh, really?
Like, songs I listen to and kind of get in the zone and focus. The one
Yeah.
thing I will slightly kind of one distinction I would draw is, in athletics, you have, the other team is the enemy. That's just, I'm not working together with the other team for any purpose. They are on the other side, and our goal is to beat them.
Mhm.
But in the legal field, I had to kind of adjust away from that dynamic. You're not always working against the opposing counsel. There are times where the court needs you to work together, or you need to work together because you need to have the judge, allow an extension of time for something, or allow additional pages, or, extenuating circumstances come up that you need something for your client. And so you need to talk to and be friendly with opposing counsel to effectuate those goals of your client. And so I think I actually was predisposed to think that there would be clear lines between the parties in litigation. And actually something I learned very early on is the ability to be a zealous advocate without being so polarizing that you then burn bridges that your client might need throughout the course of the litigation. So that was something I actually had to kind of shift a little bit from, my athletics. But in terms of exciting cases, I think it's hard to pinpoint one case, because I think, there's exciting cases because they're exciting to talk to other people about. A lot of my friends and family are not in the legal field, so they really could care less about, if I say I'm working on a brief, they understand the context. But if I get into like the nuances of it, their eyes are going to roll back. They're just not interested in that aspect of things. So exciting cases I've worked on, I think, are when my clients are in industries that I find very interesting, and industries that, friends and family encounter. So I've worked on cases for clients that are in the food and beverage space. So these brands that you interact a little bit more, like, hey, yeah, I know I've drank that drink before, or I've eaten that food product before. And so it's of interest because it's within your realm of what's familiar to you. And I find that interesting. And then exciting wise, to be honest, when you're in the beginning of your career, what's really exciting is just whenever you get, for a trial lawyer, I think whenever you just get into court. And so it's just, do I have this opportunity of actually arguing this motion in court? Like, that in and of itself is very exciting. And then just early on in my career, by nature of working at the county counsel's office, I actually had the opportunity to get into trial a lot. So I actually was in trial. I think I had, between court and jury trials, I had in excess of 20 in my first 2 years of practicing.
Oh, wow.
And they were, more discreet trials and weren't as long, it was 2 to 3 day trials where with the jury deliberating. But that experience, I mean, that was exciting. I found that motivating, the whole idea of, bringing in a jury and picking a jury, and then, doing your opening statements and your closing arguments, and questioning and cross-examining witnesses and putting the whole case together. Particularly when it was just me, I've found a lot of my experiences exciting because they're things I haven't been able to do yet. And it's the first time I get to do it. The second time I get to do it, I haven't yet lost that excitement for those moments of, when it's actually time to take that deposition, or it's time to, go into court and argue that motion that I've drafted, or go to trial. I think all these instances, I think, are probably in turn why I decided to be a trial lawyer anyways, or confirming that I just like that oral advocacy part. And I like to actually getting to put together that final presentation. I've found that to be exciting, and the motivating part is that end result that you get to have. And then, sometimes it gets deflated a bit because the court rules against you, or the jury rules against you. And then sometimes they rule in your favor, and then that's hugely vindicating. And so I find, all those aspects exciting about the practice. Not to mention, but I mean, not to overshadow the fact that there's a lot of the mundane as well in practicing law and for anyone.
I feel like within the legal industry, they do a very good job of like covering up the mundane. Like just in my like personal experiences, like all of it seems like very exciting, like surprisingly, and you don't really hear about the mundane. But like being a young, new lawyer, what's it like working with older lawyers who maybe like see you and they're like, oh, and they like talk down to you and they're like condescending and things like that, and then you like blow them out of the water and like impress them and things like that. What is it like as a young lawyer?
Sure. I think in that retelling, in the stories that I tell about my experiences, I shock people with how great, how coherent my oral advocacy skills are. I just, shock and awe, or in the telling to my family and friends, which probably 90% of the time it just is not as clear of a result. It's more like, okay, this person knows what they're talking about. They prepared. But I will say that, since the very beginning, one example I have is, I think it was my first trial, and I did everything. I made sure I had the substance prepared. I had all my outlines together. I was ready to go. I thought through the whole process, talked to a bunch of attorneys I worked with, sat in and watched a bunch of these trials. And then I get there, and in this particular county, the judge, after you've been assigned out to a courtroom, the judge then brings you back for a conference in their chambers to kind of just figure out where the case is and if everyone's ready to go. And then you go back out, and it's a lot of hurry up and wait. And then they have to go and grab the jurors. And so we're waiting for that process. And opposing counsel comes up to me and says, I'm going to have ask the judge to have all witnesses excluded from the courtroom during testimony, which it's not unheard of. I've seen that happen. But then, it was the first time I'd ever been in the, I was first chairing this trial, right? So it was up to me, and it was the first time I was in that position. I had seen this, outside of maybe in a textbook, when I was studying in law school. And so, I was thinking about it. I was like, okay, well, I can kind of understand the general motivation behind it, but how does that actually practically play out? And then I realized one of the big issues that I would have to object to is that our client representative was also a witness. And so as a result, that would then in turn mean opposing counsel. And that in the end, I think was the goal was that she was trying to exclude from the courtroom our client representative. And then I realized, I was sitting there and thinking, okay, well, your client always has a right to be present for their trial, absent extenuating circumstances. But I didn't have that rule handy. I didn't know immediately what that was. And so I don't think opposing counsel intended to, but by nature of telling me this, she kind of gave me advance notice so I could do some very quick research to make sure I had this figured out as to, why that's not the case. And so, there's a very real chance that when it was presented to the judge might have still not ruled in her favor, even if I didn't have that rule handy. Yeah. But that experience really, well, first of all, opened my eyes to the fact that I had seen her in trial, and I knew she had never done this before with more senior counsel. And so, I realized that was a very real example of, I'm just going to throw the book at her and see if she can think on her feet and see what I can get to work for my favor and for my client. And it really also just reiterated to me the fact that, there's one part of preparing for any hearing or trial, and that is the substance, right? And that's the thing that people really think about, as you should, right? Is what the questions you're going to ask, the evidence that you need to get out there, the arguments you're going to make. But there's a whole nother aspect of it, which is the procedure part. And I think that's oftentimes what attorneys sometimes forget to prep in advance. And so that's the last minute kind of researching, figuring out, because you took something for granted, and then you had no idea and could not anticipate that opposing counsel was going to throw this curveball at you. So, since then, before every hearing I have or trial, I really tried to think through, both that prepare the substantive case, but also think through what I'm taking for granted, and, think through scenarios of the way in which that might be, opposing counsel might try to throw a wrench in my plans, and then prepare for that. And of course, you can't prepare for everything, and you need to be prepared to, think on your feet. But that was one example where I I had my eyes opened. And since then, I mean, oh man, the amount of times I've been told, definitely by more senior attorneys, or just attorneys that have been practicing longer, is, they try to say, something or a certain procedure, like, the parties should do this, follow this process. And then I think, well, that doesn't sound familiar. I haven't heard that before. And then they think, oh, that's always how I do it. That's always how it's done. You've never had that happen before. And so, despite those kind of mental games and kind of psychology, you kind of always have to just take a step back and think through and not let those things impact the decisions you make. And there's no harm whatsoever in saying, actually kind of reverting and falling back on the fact that you are potentially more junior, or you might not be the decision maker in the case, and say, I gotta go take that back to the team and discuss, or I have to go take that back to the client and discuss, because, well, you actually do need to, talk about it with your client as well. So there's definitely a lot of the tricks have been used. And then in turn, I've seen, successful ways in which attorneys have kind of just addressed it, and in ways that are perfectly appropriate in the setting, and actually, consistent with our professional obligations.
Right. I think that it's really interesting to bring it back to the sports analogy again, how these lawyers kind of play dirty, and how there's all these mind games. I remember hearing a story from one lawyer about how the opposing counsel, one of the lawyers didn't like being touched, and he would just like go up to him and like bump into him, multiple times, and like throw this guy off. So it's pretty funny to hear these sorts of things. And I think it's also inspiring to hear how you deal with it as a newer lawyer, especially for the young aspiring lawyers that might be listening.
You definitely have to choose. I think in some of, like, in one deposition I had, each person is different. I mean, I've come across attorneys that are just so friendly, and that's actually how they are consistently. I've come across attorneys that are very friendly because they're trying to effectuate some sort of goal. I've come across attorneys that are friendly, and then all of a sudden you get into trial, a hearing, and then all of a sudden it's, the most vitriolic statements you've ever heard, and very choice adjectives, and it's very heated. And I've gotten, and in everything, even as simple as games like that. I had an attorney come in, I was taking a deposition, and I don't think they were very pleased that I was able to take this deposition. It was an apex witness, and we were able to, through briefing, the judge ruled in our favor, so we were able to take the deposition of this apex witness. And so we show up for the deposition, and I was waiting in the room for them to come in, and they all came in. I introduced myself to the witness, and I introduced myself to co-counsel, and then the primary counsel who was defending it just would not even look me in the eye or shake my hand. So I just had my hand outreached for 10 seconds or something like that. And so and in that second, I could have either just put my hand down and not acknowledged it, but I think you just kind of decide how you react to those things. And I just, called his name a few times to bring him to attention to the fact that I knew exactly what he was doing, but and forced him to shake my hand.
Yeah, that's pretty wild.
Yeah.
So if there is somebody out there, like a young aspiring lawyer who's inspired by our conversation, what's the best way to reach out to you or learn more online?
I mean, everything's available online. So it's, through my profile, through the firm, and my email, I think it's on there, but it's rhorton@polsinelli.com. So, or through LinkedIn. I'm always, I get reached out to on occasion by, law students, and then people that are newer in their practice. And I would just always say to newer attorneys is that you don't always have to be networking for a specific purpose, that you're looking to get a new job or you're looking to transfer. I think exploratory networking is so beneficial,
Absolutely.
especially when you're newer, because and younger in the practice, because you just don't have the years of experience that gave you the exposure to other attorneys and other practice areas. So through networking with people, regardless of whether they're in your industry or not, just, invariably I found it very successful as I meet attorneys and I find that I have an affinity towards them. I either like the way they practice, or I like the way they network, or, they've developed an incredible book of business that's very loyal to them. I think any of those things, anytime that you meet someone and they spark your interest, don't be shy to follow up with them. I think everyone is usually pretty happy to, have a 15 to 20 minute, 30-minute conversation and a cup of coffee. And not a lot of people mind talking about themselves. And it is flattering when people reach out. So, I'd always advise newer attorneys never to hesitate.
Well, thank you so much, Rebecca. I really appreciate you taking the time today. This has been Jacob Wells for Latte with Lawyers. And we really appreciate Rebecca Horton of Polsinelli for joining us today. And I want to thank our sponsor, EmotionTrac, without a K, that uses artificial intelligence and mobile app audiences to economically and quickly gather focus group research and data for trials and mediations. So thanks again, Rebecca. Really appreciate it. All right, take care.